Welcome to Legal Translation Quick Tips, brought to you by Translating Lawyers. Today we're going to talk about sources of law and why they should matter to legal translators. And if you're wondering what we mean by sources of law, well, of course, that definition is going to vary according to context. In a literal sense, sources of law are the original documentary source of our information concerning the existence of a rule of law. So, for example, law reports or civil codes are a source of law in the literal sense of the term. In the historical sense, sources of law are the mediate or immediate sources original, from which rules of law derive their content as a matter of legal history. So in that sense, the writings of Blackstone and Coke are sources of English law because they enunciate rules which are now embodied in judicial decisions and acts of the English Parliament. But the question still is, what exactly are the sources of law of each legal tradition? And more importantly, how does that affect legal thought? And the reason why that's important is because that's precisely the aspect in which sources of law affect translation. The way legal actors think about the law affects how they communicate as much as it affects the different connotations that a word can carry across the legal system. So if we understand sources of law, we can also understand why legal actors in the common law world refer to case deciders as courts, for example, while their counterparts in the Spanish civil law world refer to jueces instead. And more importantly, we'll also be able to understand the different connotations of that linguistic choice. So what are these different sources of law? Well, let's start with the sources of common law, or fuentes del derecho anglosajón. Common law has primary and secondary sources. Its primary sources, or fuentes primarias de derecho, are the law itself, and they include constitutions, or constituciones, administrative rules, or normas administrativas, statutes, or leyes escritas, and court cases, or jurisprudencia. Meanwhile, secondary sources, or fuentes secundarias, are where the law is at. In other words, they restate the law while also discussing, analyzing, describing, explaining, or critiquing it. The Spanish-speaking civil law tradition also has primary and secondary sources, just not necessarily the same ones as the common law tradition. Throughout Latin America and Spain, sources of law will typically boil down to legislation or legislación, custom or costumbre, and general principles of law or principios generales de derecho. And secondary sources will typically include precedent or precedente and the writings of legal scholars, which we refer to as doctrina. And now that you know what sources of law are and where to find them, you can start building up your glossaries. And that, my friends, is hard work worth doing that will turn you into a legal translation superstar. To learn more about legal translation, follow us on Facebook, Twitter, or Instagram under the handle @TranslatingLawyers, or subscribe to our YouTube